Hi, my name is Akiva Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan, and we're continuing our video series on educational issues designed to educate the public about interesting things that pertain to family law. Today, we're going to talk about emergency custody hearings, so please subscribe to our channel. There are times when the court will accept on their emergency docket certain cases that take priority over others. Sometimes not. The court's definition of the word emergency is different than yours and mine. I might think, for example, if somebody's supposed to bring back the child by a certain time and they didn't, they're ghosting us. There's no person on the other line. That's an emergency. The court, though, will not see that as an emergency unless we can show that there's some harm coming to the child. In my situation, maybe it's just that somebody's out of range, had a bad traffic delay, and their phone's not working. Maybe that's what it is. That could very well not be an emergency. So the court is going to devote its emergency docket primarily to situations where it really believes that the child's well-being is in jeopardy. That is the purpose of emergency hearings. That is the purpose of the court's emergency docket, to protect a situation where the child, may be in jeopardy. And so the court, somebody can file a motion, request emergency relief, file an emergency petition for, either change of custody or custody ruling or some emergency request that is designed to stop and prevent a bad thing from happening. So that's the purpose of the court's emergency docket. And what the court's going to weigh in is that this is a drastic remedy. Your emergency orders generally are going to come on the say-so of one person without having the other side weigh in. They're going to tend to come ex parte, an emergency order granted with the understanding that the parties are going to have to come in very shortly and argue whether the emergency order should continue. But the fact is, the courts consider, is there a fear of, for example, irreparable harm? If we don't do this, might the child, for example, be taken out of a jurisdiction? We'll never see the child again. That's a perfect example of why the court might enter an emergency order ordering that the child not be removed from the jurisdiction. What outcomes can you expect, and what will be the next step? The court's either going to grant that petition or deny it. But even if the court says, you know what, I understand you're upset, I understand, and we empathize with you, but we don't feel that belongs on our emergency docket, it doesn't mean that the court won't give you as early a date as possible to have a hearing on that issue, to decide that very item that you seem to feel is an emergency. The only difference is the court might not decide it on an ex parte basis. The court might rather bring in all parties and let everybody be heard on the issue, and then make the decision on whether or not to grant that, what you called, request for emergency relief. Sometimes the court will find that an emergency may exist, but there may be a way to address the issue, all the while letting everybody weigh in on it without the extraordinary remedy of an ex parte ruling. An ex parte ruling means a ruling where there's only one person weighing in, the other party's not here. The ex parte, that party is out, is exited from the picture. So the court generally doesn't like to do that. The court likes to hear evidence from both sides before it makes a ruling. Every now and then the court will deem an emergency. You get a picture of an infant with cocaine and syringes right around him, and your request is that the other side not be allowed to have the child unsupervised because look what they exposed the child to. The court may very well grant such order, but will likely say, I want an immediate hearing. I want to hear what's going on. I want to hear the defense to that before we make any permanent positions, and we take any permanent positions in this regard. Now, if you have any questions about your case, reach out, and we'll be glad to help you out.